Good day, dear listeners. It's Lena again, and I'm glad you're here. My boss told me I had no stake in the company. My original employment contract said otherwise. I found it in a banker's box I almost threw away. Stay with me, because the document that changes your position isn't always in the filing cabinet. Sometimes it's in the box in the storage room that nobody opened in 7 years. We sign things in the beginning with the hope of good faith, and we file them away because we believe we'll never need them. And then the company grows, and the terms improve for everyone above you, and the document you signed becomes the thing they want you to forget. Rachel Sommer had not thought about her original employment contract in 7 years. Neither had her employer, until she found it. There is a particular experience that belongs to people who join companies early, before the funding rounds and the growth and the acquisition conversations, that is difficult to describe to people who have not lived it. You join a small company because someone with an idea needs someone with skills, and the exchange is asymmetric. You are bringing expertise that the company cannot yet afford to pay for at market rate. And in exchange for that discount, you are offered something that seems speculative at the time, an ownership stake, a piece of the future value. The thing that is called equity, and that is usually described in the language of hope rather than expectation. The percentage numbers feel abstract when the company has 11 employees and a leased office and a product in early development. They only become concrete when the acquisition conversation starts. Rachel Sommer had been having that realization slowly. Over the weeks since Harkin Medical announced the acquisition discussions, she had spent 7 years building the company's flagship device from concept sketch to EFTA clearance, and she understood, in the bone-deep way of people who have made something, that the device accounted for 61% of Harkin's annual revenue. She knew what she had contributed. She had simply not examined, recently and carefully, what her original contract had said that contribution was worth. She was about to find out. Rachel Sommer is 39 years old. She grew up in a suburb of Cleveland and came east for graduate school in biomedical engineering, arriving in the Boston area in the mid-2000s with the specific ambition of people who have found the intersection of what they are good at and what they care about. Medical devices, the design and development of instruments that go into or onto human bodies and are required by federal regulation. To be safe and effective suited the combination of her technical precision and her underlying desire to make things that mattered. She spent 3 years at a larger firm learning the regulatory landscape, the EFTA clearance process, the documentation requirements that separate a medical device concept from a device that can be sold and used. She was good at it. She was very good at the documentation, which is not glamorous and is also the spine of the entire enterprise. When Gerald Fitch recruited her to join Harkin Medical 7 years ago, Harkin had 11 employees, a Class II device in early development, and a Series A funding round that had just closed. Gerald was 51 at the time and had done this before, built a small device company to exit. And he understood, better than most founding CEOs, that the quality of the regulatory and development work done in the early years determined the quality of the exit years later. He needed someone who could build that function. Rachel was the person he had identified as the right hire. He offered her the role of product development director, a salary that was below her market rate by approximately 18%, and a sentence that he said with the casual conviction of someone who considers it merely a statement of the obvious: "We're giving you an ownership piece because we want you to build something with us." The ownership piece was in the employment agreement. Section 6A specified the initial equity grant of 3.0% of fully diluted equity as of the date of the agreement, subject to a 4-year vesting schedule with a 1-year cliff. Section 6B, the paragraph that would matter years later in a pre-close equity settlement meeting, specified the anti-dilution floor. Employees shall not be diluted below 2.2% in any future financing round without employees' written consent. Rachel read the contract when she signed it. She noted the equity provisions. She kept a copy in a manila folder labeled Harkin. Original, boxed it with the Series A term sheet when she moved offices, and filed the box in a storage unit she maintained for professional documents. And then she went to work and did not think about the contract for 7 years, because the contract was not the thing she was building. The device was, and the regulatory dossier was, and the team was, and those things required all the attention she had. Donna Sommer is Rachel's sister, 2 years older, a CPA with the specific practical wisdom of accountants who have spent enough time reviewing other people's financial decisions to have developed an instinct for where trouble usually lives. She was visiting Rachel in Cambridge for a weekend in the early fall when the acquisition discussions were public knowledge inside the company. And she asked the question that changed everything. They were eating takeout on Rachel's couch, and Rachel was explaining the acquisition timeline and the projected close, and she mentioned the equity payout, the $210,000 figure that Gerald had cited at the all-hands meeting for her level and position. Donna put down her fork and said, "What does your contract say?" Rachel said, "That's the restructured figure." Gerald explained the cap table changed in 2020. Donna said, "That's not what I asked. What does your original contract say?" Rachel looked at her sister. She said, "I'd have to find it." Donna said, "Find it." The storage unit was up for rent renewal the following month anyway. Rachel drove out on a Saturday, opened the unit, and began going through the boxes. The banker's box was in the back, behind 3 boxes of early-stage regulatory documents that she had kept for record-keeping purposes. It was labeled Harkin, Series A/Originals in her handwriting from 7 years ago, the same neat print she used for regulatory file labels, because organization was not a professional habit for Rachel. It was simply how her brain worked. She lifted it out, carried it to her car, and drove home. She found the manila folder inside, labeled Harkin, Original in the same print. Inside, the offer letter, the signed employment agreement, and her copy of the Series A term sheet. She opened the employment agreement to Section 6 and read both paragraphs. She read Section 6B twice. She looked at the number, 2%, and she looked at the $94 million acquisition valuation she had seen in the deal announcement summary. She did the arithmetic on her phone's calculator. She looked at the result for a moment. Then she called Peter Orlin at 7:45 in the morning. Peter Orlin is 51 years old and has been practicing employment and equity law in Boston for 22 years. He is the kind of attorney who receives calls at 7:45 in the morning from people who have just read something in a document and cannot wait until business hours, and he answers them, because in his experience, the people who call at 7:45 in the morning have usually found something real. He listened to Rachel describe the agreement. He asked her to read Section 6B aloud. She did. He was quiet for 4 seconds. Then he said, "Can you come in this morning?" She came in at 10. She brought the employment agreement and the offer letter. Peter read both documents thoroughly and asked Rachel a series of questions, Had she signed any document in 2020 amending the equity terms? Did she have any record of receiving and signing an updated employment agreement? Was there any communication from HR in which she had explicitly consented in writing to a reduction of the equity floor? To all three questions, Rachel's answer was no. She had received an email from HR in 2020 with a subject line that referenced a revised equity schedule. She had the email in her archive, and the email had contained an attachment. She had glanced at the attachment at the time and understood it as a general communication about the cap table restructuring. She had not signed anything. She had not replied to confirm receipt with a statement of consent. She had continued in her employment and not mentioned the email. Peter read the email she pulled up on her phone. He looked at Section 6B of the original agreement. He said, "The contract required your written consent for any modification to the anti-dilution floor. An email with an unsigned attachment is not written consent. Continued employment is not written consent under Massachusetts law when the original agreement contained an express written consent requirement. Do you know if HR has a copy of a signed updated agreement from you?" Rachel said. "Gerald told me HR would send it over." Peter said, "Let's ask HR directly." Today, they contacted HR that afternoon. HR produced the 2020 email and the attachment. They did not produce a signed updated agreement from Rachel. The attachment had been sent to all equity holders simultaneously. The email had not requested or received acknowledgement of consent. No individual signed consent document existed for Rachel. Gerald had already called Rachel by mid-morning. He was smooth and fast and confident, in the way of CEOs who have navigated the pre-close period of acquisitions before and understand that it is a time when complications are expensive. He said he had heard she had some questions. He said the 2020 restructuring had been disclosed to all employees. He said if she hadn't signed the updated agreement, they could clean it up before close. Rachel asked if she would receive her 3% at acquisition. He said the cap table was what it was. She asked if he had her signed updated agreement on file. He said HR would send it. She said she would like to see it today. He said, "Rachel, don't make this harder than it needs to be." She said, "I'm not the one making it hard." She ended the call. She called Peter and told him about the conversation. He said, "Good." He said, "Don't have any more direct conversations with Gerald about this. That's my job now. Let me tell you what happened next in the procedural sequence, because it moved quickly, and it moved with a complexity that came from an unexpected direction." Harkin's attorneys filed their position with Peter within 48 hours. Rachel's continued employment following the 2020 restructuring email constituted implied acceptance of the new equity terms. This is an argument that sounds plausible until you examine the contract that allegedly governed the relationship. The original employment agreement did not merely grant the equity. It specified in Section 6B the precise mechanism by which the equity terms could be changed. Written consent, not implied consent. Not consent inferred from continued employment. Written consent. The contract's own terms told you how to modify the contract's own terms, and the method was specific and had not been followed. Peter's response was efficient. The implied acceptance doctrine cannot override an express written consent requirement in a valid contract. This is Massachusetts contract law, not a novel or disputed point. He attached the relevant case authority and the applicable statutory provisions. He offered to be available for a call. Harkin's attorneys requested time to review. While they were reviewing, something happened that Rachel had not anticipated. Nate Yoon, the lead counsel for the acquiring company, flagged the discrepancy independently. His team was reviewing Harkin's equity documentation as part of standard acquisition due diligence, and when they ran the cap table against the employment agreements on file. The standard step of confirming that every equity holder's stake was accurately reflected and legally documented, they found that Rachel's current equity listing of 0.6% could not be reconciled with the anti-dilution floor in her original employment agreement, and that there was no signed consent document on file authorizing the change. Nate placed a hold on the equity distribution table and called Peter's office. Peter called Rachel to tell her. He said, "The acquiring company found it themselves." Rachel said, "Before or after we raised it?" Peter said, "About the same time." Nate's team was doing standard diligence. Rachel was quiet for a moment. She said, "So even if I had thrown the box away, they might have found it." Peter said, "Maybe, though not having the original agreement would have complicated your position. You found it first. That's better." She said, "I almost didn't find it." He said, "But you did." Gerald called Peter's office twice during the week before the pre-close equity settlement meeting. Peter did not return the calls. He was not being difficult. He simply had nothing to discuss privately with Gerald, because the discussion would happen at the table, with the documents, in the presence of everyone who needed to be present. Gerald was used to calling his way through complications. This was a complication that could not be called through. The pre-close equity settlement meeting was held in a conference room in downtown Boston on a morning in late October. Present, Gerald, Harkin's attorney, Peter, Rachel, and Nate Yoon from the acquiring company's legal team. The room was bright and cool. The conference table was the kind of wide, polished rectangle that is designed to accommodate a certain number of people on each side, with the clear implication that the sides are in opposition. Harkin's attorney made the opening argument, a negotiated compromise at 1.4% rather than 2.2%, acknowledging that the full anti-dilution floor was technically applicable, but arguing that the acquiring company's timeline and the disruption of reopening the equity table justified a middle position. It was a lawyered argument, coherent, structured, offering the other side a partial concession in hopes of avoiding the full one. Rachel heard it and looked at Peter. Peter placed the original employment agreement in the center of the table, open to Section 6B. He said, "The floor is 2.2%. The requirement for a written waiver was not met. We're asking for the floor." Nate Yoon leaned forward and read Section 6B. He read it carefully, the way lawyers read contracts in moments when they want to be certain they are reading what they think they are reading. Then he looked at Harkin's attorney and said, in the quiet, precise voice of someone who has made a professional decision, "This is clean. You need to honor the floor." Harkin's attorney consulted Gerald. The consultation was brief. Gerald looked across the table at Rachel. She was looking at the contract, not at him. She had been looking at the contract since Peter placed it on the table. She was reading Section 6B again, not because she didn't know what it said, but because it was the document, and the document was what mattered, and she wanted to be looking at it when the answer came. Gerald said, "Fine." It was, Rachel told her sister Donna afterward, the smallest word she had ever heard him use. The acquisition closed in November. Rachel's equity at close was corrected to 2.2% of the $94 million valuation. Her payout at closing, $2.07 million. Gerald sent a company-wide email that afternoon praising the team and describing the acquisition as the result of 7 years of collective effort. Rachel's name appeared in the second paragraph, between two colleagues who had joined the company in its Series B phase. She read the email once. She had already boxed her desk items and made arrangements for the handoff of her regulatory files. Let me tell you about what Rachel did after the close, because the afterword is part of the story too. She did not leave the industry. She had spent 7 years in medical device development, and she was not done with it. She had too many remaining problems she wanted to solve, too many device concepts that were still only ideas in notebooks she carried everywhere. She took 3 months, the first real unstructured time she had taken since graduate school, and she traveled and read and thought. She visited her sister in Cleveland and spent a week being Donna's sister rather than anyone's director of anything. Donna made her cook dinner twice, which Rachel found both annoying and restorative. She joined a Series B medical device company in Cambridge in the spring, smaller than Harkin had been at its peak, with a device in early development that reminded her of the early Harkin years in the best possible way. She negotiated her employment agreement personally and carefully, with Peter reviewing every section. The equity clause was clear. The anti-dilution provisions were specific. The written consent requirement for any modification was in explicit language in the governing paragraph. She keeps the original Harkin employment agreement in a folder on her home desk, not in a banker's box, not in storage, in a folder, in her desk, where she can find it in 30 seconds. The folder is labeled in her handwriting, Original. She took the banker's box to a document shredding service, because the early regulatory documents inside it were from the pre-clearance phase and were no longer needed. The box itself she disassembled and put in recycling. She kept the manila folder that had held the employment agreement. She transferred it to a new folder. She threw away the old one. She has thought about what would have happened if she had thrown the box away, if the storage unit renewal had felt like a burden rather than a sorting opportunity, if she had called the storage company and asked them to dispose of unclaimed items, if Donna had not asked the question that sent Rachel back to look at what her original contract actually said. Peter has told her that Nate Yoon's due diligence might have surfaced the discrepancy regardless. That's probably true, but might have requires a good faith acquiring company with thorough legal counsel, and not all acquisitions have those. Sometimes the only person looking out for your original terms is you. She has talked to colleagues carefully and without specific reference to her own case, about the habit of keeping original employment agreements and reviewing them before significant company events. She has suggested, gently, that the equity section of an employment contract is worth reading again when an acquisition conversation starts. She has been specific about one thing: if the original agreement requires written consent for any equity modification. Check whether that written consent was ever given. Several of her colleagues have found things when they checked. Not always the same thing Rachel found. Sometimes a vesting acceleration clause that had been quietly removed. Sometimes an equity pool commitment that was never properly documented. Once, a colleague found a retention bonus trigger that the company had forgotten to honor. Not every discovery is worth fighting. Some are. The ones that are worth fighting are the ones where the original agreement is clear about what was required and the required thing was never done. Rachel says, when colleagues thank her for the advice, it's just a document. Keep your documents. Read them when it matters. She means it without irony. She has learned from the inside what a document can say for you when the person who needs to be reminded of what they agreed to has forgotten, or is pretending to have forgotten, or has simply reorganized the table and hoped you wouldn't notice. She found the box. She read the paragraph. She called Peter at 7:45 in the morning, and Gerald said fine in the smallest voice she had ever heard him use. That is what the paragraph in Section 6B was worth. Keep your originals, especially the ones from the beginning when someone wanted you enough to put it in writing. That's when they make the promises that matter most, and that's the document you need when they try to walk them back. Thank you for listening today. I'd love to know where you are. Leave your city in the comments. If this story reminded you of a document you should probably find, go find it. Like this episode if it helped. I'll see you next time. Let me go further back into Rachel's time at Harkin. Because 7 years of building something is not a compressed fact. It is a sequence of decisions and trade-offs and small daily commitments that accumulate into an outcome. And the outcome in Rachel's case was $94 million worth of company value built substantially on her work. And understanding that accumulation matters for understanding what the contract meant when it finally came off the shelf. When Rachel joined Harkin, the flagship device was a concept document and a bench prototype that had been demonstrated under controlled conditions exactly once. The concept was strong, a Class II cardiac monitoring device with a form factor that reduced the burden on ambulatory patients significantly compared to the existing competitive options. But a concept demonstrated once under controlled conditions is approximately as far from FDA clearance as a recipe written on a napkin is from a restaurant that has passed its health inspection and served 1,000 customers. The distance between those 2 points is measured in clinical trials, biocompatibility testing, human factors studies, risk management documentation, predicate device research, 510K submission preparation, FDA correspondence, and the response to any additional information requests that the FDA issues after reviewing the submission. Each of those steps produces documentation. Each piece of documentation is a controlled document. Each controlled document must be accurate, complete, version controlled, and traceable to the design history file that is the regulatory spine of the entire device's development. Rachel built that system from scratch. There was nothing at Harkin when she arrived. No document control procedure, no design history file structure, no risk management framework, no regulatory submission template. Gerald had hired a contract regulatory consultant before Rachel arrived, and the consultant had left behind a folder of templates that Rachel looked at once and set aside, because templates are not a system, and a system was what Harkin needed. She built the system over her first 6 months. She hired the first 2 members of her team in month 7. She began the formal design controls process in month 8. Have you ever built something from foundation up? Have you ever known that the thing you are making on a Tuesday afternoon in a Cambridge office is the document that will govern whether a product can be sold in the United States? That is a specific kind of accountability that concentrates the attention in a particular way. Rachel has described it to people who ask about her work as the experience of knowing that the document is the product, that the device and the documentation of the device are not 2 separate things, but one thing, and that the one thing has to be true and correct and traceable, or it does not work. She ran the 510K submission in year 3. The FDA's review period ran to its statutory 90 days and then extended by 30, which is common. The FDA's request for additional information came on a Friday afternoon, as these things often do, and Rachel spent the weekend drafting responses. The clearance letter arrived 6 weeks later. Gerald sent an all-company email. The engineering team ordered pizza. Rachel updated the design history file and began the post-market surveillance plan. By year 5, the device was in commercial production. By year 6, it was generating 61% of Harkin's annual revenue. By year 7, when the acquisition conversations began, it was the primary asset the acquiring company was paying $94 million to obtain. Gerald understood this. He was not a man who failed to understand the arithmetic of his own company. He had restructured the cap table in 2020 during a bridge financing round, and the restructuring had the effect, whether intended or incidental, Rachel has never been certain, of reducing the equity percentages of early employees and increasing the pool available for later investors and management. He sent the restructuring email to all equity holders. He did not request individual written consents. He did not follow the process that at least one of his early employment agreements expressly required. Rachel does not know whether he reviewed her original agreement before sending the email, or whether he reviewed it and decided the implied acceptance argument was worth the risk, or whether he simply moved through the restructuring as an operational matter and did not pause to check each equity holder's contractual terms. What she knows is that he did not have her signature on an updated agreement, and that when she asked him directly, in the phone call before she had reached Peter, whether he had her signed updated agreement on file, he did not say yes. He said HR would send it. He did not say yes. She noted that. The phone call with Gerald is something Rachel has thought about more than most of the other events in the story. Not because it was the critical moment. The critical moment was Section 6B and Peter's analysis and the conference table, but because of what the call revealed about how Gerald understood the situation and her place in it. He called her before she had reached her attorney. He was efficient and warm and confident. He framed the equity discrepancy as an administrative issue rather than a contractual dispute. He invited her to let him clean it up before close, which, she understood, meant, let me tell you what you're getting before you figure out what you were supposed to get. He said, don't make this harder than it needs to be. He said it to the person who had cleared the device that made the company worth $94 million. She said, I'm not the one making it hard. And she ended the call. She has not spoken with Gerald since the equity settlement meeting. He sent the company-wide email, and she read her name in it. She did not reply. She had cleared out her office that morning. Let me tell you about the 10 days between Peter's initial review and the pre-close meeting, because those days had a particular quality that is worth describing. Rachel went to work each morning. She ran her team's project planning meetings. She reviewed regulatory documents and provided comments. She answered questions from the acquiring company's due diligence team about the device's design history, its clinical data, its post-market surveillance results. She was cooperative and thorough in these answers because the device was her work and she wanted it to be understood correctly, and because her professionalism in the due diligence process had nothing to do with the equity dispute, and she was not going to allow the equity dispute to color it. Have you ever had to separate two things that are emotionally entangled and hold them apart through an act of sustained professional discipline? The regulatory due diligence and the equity dispute were entangled. They were both about Harkin and her place in it. And she held them apart every day for 10 days by doing the professional thing in both directions simultaneously. She answered Nate Yoon's team's questions about the device with the same precision she brought to every regulatory matter. She deferred all equity questions to Peter. She did not discuss the dispute with colleagues. She did not mention it at the weekly all-hands. She arrived at the pre-close equity settlement meeting with 7 years of professional discipline intact and sat across the table from Gerald with the composure of someone who has separated what matters from what is complicated and decided to focus on what matters. What mattered was Section 6B. Peter put it on the table. Nate Yoon read it. Gerald said fine. The composure she maintained during those 10 days is the thing she finds hardest to explain to people who were not there. Not hard in the sense of painful, she has made peace with the outcome, but hard in the sense of difficult to describe accurately. She was not performing composure. She was not suppressing an underlying turbulence and projecting a controlled surface. She was composed because the situation was, at its core, simple. She had a contract. The contract said what it said. Peter understood what it said. Nate Yoon's independent review had confirmed what it said. The legal position was clean. The outcome was, in Peter's professional assessment, highly likely to resolve in her favor. There was, genuinely, nothing to be turbulent about. The document was doing its work. She only needed to let it. This is something she has thought about since, the relationship between having a strong position and feeling calm. She thinks most people, when they discover they have been shortchanged by a significant amount of money, feel anger. She felt something closer to clarity. The kind of clarity that arrives when a fact you suspected turns out to be exactly the fact you suspected, and the documentation confirms it, and the attorney reads the documentation and says, "Yes, this is what I thought it was." She did not need to be angry. The contract already contained everything she needed. Her job was simply to hold it and let Peter present it. Peter Orlin, for his part, described the case to her at the close of the settlement meeting as one of the cleaner employment contract disputes he had seen in 22 years of practice. He said, the original agreement was unambiguous. The modification process was clearly specified. The specified process was not followed. That's the whole case. Rachel said, "It seems like it should always be that simple." Peter said, "It usually isn't, because people don't keep the original agreements. You kept yours." She almost didn't. She had driven to the storage unit that Saturday, intending to consolidate 2 boxes into one and return the rest to storage. The banker's box was already in the keep pile before she opened it. She had kept it because she is the kind of person who keeps professional records, and because the regulatory documents inside it were part of a history she was not yet ready to formally archive. She had not gone to the storage unit specifically for the employment agreement. She had gone because the rent renewal was due, and she needed to decide what to keep. The folder was there because she had filed it there 7 years ago with the precision of someone who files things correctly, even when correct filing feels excessive. Harkin, original, 2 words, and a dash. The right box, the right folder, the right label. 7 years of sitting in storage, and when she lifted the folder out and opened it, the agreement was exactly where she had put it. What would you have done? If you had been Rachel, sitting on the couch with Donna, hearing that your equity was a fraction of what your original agreement described, would you have known where to look? Would the original agreement have been somewhere you could reach it in a weekend? These are the questions that Rachel now thinks about when colleagues mention their own employment contracts. And these are the questions she gently raises when the moment is right. She keeps originals. Not just for legal leverage, though that matters, but because the original is the record of what was promised before the relationship became complicated by growth and money and the gradual redefinition of terms that happens in organizations that are succeeding. In the beginning, when a company needs you, they tell you what you are worth. They put it in writing. That document, the one from the beginning, from the hope and the good faith and the offer that was meant to build something together, that document is the most honest thing they ever sign with you. Keep it somewhere you can find it. And if the company is acquired, read it before you celebrate. There is something about the morning of the settlement meeting that I have not told you yet. Rachel arrived at the conference building 20 minutes early. She sat in the lobby with a cup of coffee from the cart near the entrance and reviewed her notes, not the contract. She had the contract with her, and she knew it well enough to recite Section 6B from memory by that point. But the notes she had made over the previous 10 days about the project history, the regulatory timeline, the development milestones and their dates, she had not been asked to bring this information. Peter had not suggested it. She brought it because she is the kind of person who prepares thoroughly even when thorough preparation is not formally required. Because you never know which fact matters until someone asks the question that needs it. No one asked. The facts in the room were the contract facts, and the contract facts were sufficient. But she sat in the lobby with her coffee and her project notes, and she felt, for the first time since Donna had asked her original question at the kitchen table in Cambridge, something that was not quite satisfaction, but was adjacent to it, the recognition that 7 years of careful documentation, of building and maintaining and preserving the records of her own work, had produced not only the device clearance and the company's revenue, but also the document she was about to place, through Peter, in the center of a conference table. The same habit of mind that made her a good regulatory professional had made her a person who kept her original employment agreement in a correctly labeled folder in a banker's box in a storage unit for 7 years without thinking about it. These were not separate habits. They were the same habit, applied to different objects. She thought about that in the lobby. She thought, I have been doing this my whole professional life, keeping the documents, labeling them correctly, putting them somewhere I can find them. It has never, until this morning, had a dollar figure attached to it. $2.07 million. That is what the habit was worth. In this instance, at this company, at this acquisition valuation. She did not know what to do with that number except set it aside and go up to the meeting. The elevator opened on the 14th floor. She walked to the conference room, which was already warm and bright with the October morning light coming through the east-facing windows. She was the first to arrive. She set her files on the chair beside her, accepted coffee from the assistant who appeared with a carafe, and waited. Harkin's attorney and Gerald arrived 3 minutes later. Peter arrived 1 minute after that. Nate Yoon and a junior associate from his firm arrived last, at exactly the scheduled time. Nate shook hands around the table with the brisk efficiency of someone who has a full calendar and is already thinking about the next item. He sat across from Gerald's attorney, not across from Gerald. A placement choice that was either deliberate or incidental, but that positioned him as another professional at the table rather than a party to the dispute. The meeting ran 42 minutes. Rachel spoke 4 times, once to confirm her understanding of the equity discrepancy as described, once to confirm she had not signed a written consent to the 2020 modification, once to confirm she had the original agreement available, and once at the end when Gerald said fine and Nate said the table would be corrected before close, and asked Rachel if she had any additional concerns. She said no. She said thank you. She picked up her files. Gerald was at the door before she was. He did not stop to speak to her. He walked past with the expression of a man who has processed a financial loss and is already reorganizing his internal narrative to incorporate it. Rachel did not try to catch his eye. She had said what she needed to say, and the document had said the rest. And there was nothing left to add. Peter walked her to the elevator. He said the correction would be documented and confirmed by Harkin's attorneys within 48 hours, and that close was still on schedule. She said, "Good." He said, "How are you?" She said, "I'm ready for this to be over." He said, "It almost is." She pressed the elevator button. The doors opened. She said, "Thank you, Peter." He said, "Thank the folder." She thought about that on the way down. Thank the folder. The manila folder with the 2-word label in her own handwriting from 7 years ago. The document inside it that described what someone had been willing to put in writing when they needed her. The clause in the contract that said she could not be taken below 2% without the consent she never gave. The folder was on her desk at home when she got back to Cambridge that afternoon. Peter had returned the original after making certified copies for his file. She sat at the desk and looked at it for a moment. Then she opened her desk drawer and put the folder inside, in the front position where she could reach it without moving anything else. And closed the drawer. She made dinner. She called Donna. She said, "It's done." Donna said, "Tell me everything." Rachel told her. Donna said, 2 million. Rachel said, 2.07. Donna said, "Because you kept the folder." Rachel said, "Because you asked where it was." Donna laughed. Rachel laughed. They talked for another 40 minutes about other things, Donna's kids. A trip they were planning, the relative merits of the Cleveland suburbs versus Cambridge as places to live, the ordinary conversation of sisters who call each other often enough that the significant events are contextualized by the unremarkable ones. By the end of the call, the settlement meeting felt like a thing that had happened and been processed, and could be set alongside everything else. The acquisition closed in November, as scheduled. Rachel was at her desk at the new company when the funds cleared. She received a confirmation email from Peter and a notification from her bank. She read both. She forwarded Peter's email to her personal archive. She labeled the folder Harkin Final. Then she turned back to the regulatory document she had been working on for the new company's device, an early-stage document, the beginning of a design history file, the foundation of another development process. She had been at the new company for 3 weeks. There was a lot to build. She has built it before. She knows how it goes. And she knows now where to keep the paper that describes what she was promised for doing it. I want to tell you about the week after the close, because there is a detail in it that belongs to this story. Rachel had arranged for her office to be cleared the morning of the settlement meeting, not because she knew with certainty that the day would close the chapter, but because she had made a decision, independent of the outcome, that Harkin was finished for her. 7 years is a complete thing. The device was cleared and producing and in the market. Her team was solid and would continue without her. The acquisition would bring in new leadership that would set new directions, and those directions would not be directions she had helped set. And that was the right time to leave. She had lined up the new role months earlier. She had given Gerald notice the day after Nate Yoon's hold appeared on the equity table, which Gerald received with the controlled politeness of a man who understands he cannot object. She boxed her office herself on the morning of the settlement meeting, before she drove downtown. She carried 2 boxes to her car. One contained professional materials, regulatory reference documents, a few books, her desk copies of the EFTA guidance documents she had used most often. The other contained personal items, a photograph of the team from the clearance party, a small succulent she had kept on her windowsill for 4 years, a coffee mug she had bought at the MIT Museum in the year she joined the company. The personal box was lighter than the professional one. This seemed right to her. 7 years of professional work produces a substantial weight of documents and references and regulatory frameworks. 7 years of personal attachment to a workplace, an office, and a team and a project produces something less tangible and, when it is packed into a box, smaller than you expect. She drove downtown with both boxes in her trunk. After the meeting, she drove back to Cambridge and carried them up to her apartment. She unpacked the professional materials into her home office shelves. She put the succulent on the kitchen windowsill, where the light was better than it had been at Harkin. She put the mug in the cabinet next to the other mugs. She looked at the clearance party photograph for a moment and set it on the bookshelf. She did not cry. This surprised her slightly, because she had expected to feel more when it was finally over. What she felt instead was the specific lightness of completion, the way you feel at the end of a long project when the work is done and the documentation is filed, and the device is cleared and you can stop holding the weight of its undone status. The chapter was closed. The next chapter had already started. She had begun it deliberately, which is the only way she knows how to begin things. 3 days after the close, she drove to the storage unit. She emptied the remaining boxes, the early Harkin regulatory documents that she had kept for professional reference, into the shredding bin that the storage facility maintained for tenant use. She broke down the empty cardboard boxes and placed them in the recycling bin. She swept the storage unit floor, which she does every time she vacates a space, because this is simply the way she treats spaces that have served her. The unit was empty. She handed back the key. She drove back to Cambridge. She made coffee and sat at her home desk in the late afternoon light, with the succulent on the kitchen windowsill visible from where she was sitting, and the new company's regulatory structure documents open on her screen. She opened her desk drawer. The Harkin original folder was still there, where she had put it 3 weeks earlier. She took it out, held it for a moment, and placed it in the filing section of her desk, in the rear of the drawer, behind the current documents, where it would sit as an archive rather than an active file. She labeled the divider tab in her small, neat print, Harkin/closed. Then she pulled up the new company's offer letter, which was in a folder labeled correctly in the same print, in the same habit of mind, new, original. She read Section 7 again. The equity terms. The anti-dilution provisions, the written consent requirement for any modification. She had negotiated that clause personally. Peter had drafted the language. The CEO of the new company had read it, noted it, and signed without objection. He was the kind of CEO who signs employment agreements with strong equity protections, because he understands that the people who join companies early are taking a risk that deserves protection, and that making the protection explicit in the contract is both fair and good management. Rachel noticed this about him in the negotiation. It was one of the reasons she chose the role. The new device was early. The regulatory path was long. There was a lot of work ahead, and none of it was certain. She was good with uncertainty. She had always been good with it, had understood from the beginning of her career that the specific uncertainty of early-stage device development was the condition under which she did her best work, because the uncertainty required the precision that she brought to it and rewarded the patience that she had learned to maintain. She had the contract. She had the original. She knew where it was. Everything else was the work, and the work was already started. That was enough. There is one more thing, and then this story is done. Donna called Rachel a week after the close with a question. She said, "Did you ever find out if Gerald knew about Section 6B when he sent the restructuring email?" Rachel said, "I asked Peter." Donna said, "What did Peter say?" Rachel said he didn't know and it didn't matter. Legally, Donna said. "But what do you think?" Rachel was quiet for a moment. She said, "I think he knew. I think he read the agreement at some point, probably in 2020 when he was organizing the restructuring. And he made a calculation that most people don't keep their original agreements for 7 years, and that a 2020 email to all equity holders would be close enough to a modification that no one would challenge it. I think it was a reasonable bet. Statistically, most people don't keep the papers." Donna said, "But you kept the papers." Rachel said, "I kept the papers." She did not say this with triumph. She said it as a plain statement of fact, in the same tone she uses for regulatory observations and clinical data interpretations. Here is what was true. Here is what happened. Here is the outcome that followed from the combination of those two things. She kept the papers. The papers said what they said. The outcome followed. If you are a person who signs employment agreements, and if you are working, you are a person who signs employment agreements, do one thing after listening to this story. Find your original, the one from when you were hired, from when the company was smaller or newer or more urgently in need of you. Read the equity section if there is one. Read the section about what it takes to modify the agreement. And then put it somewhere you can find it in a weekend, without driving to a storage unit, without sorting through boxes, without depending on a rent renewal notice to prompt the search. The clause in the contract doesn't protect you if you can't produce it. The folder is the difference between the number you were offered and the number that was yours. Thank you for being here today. Leave me your city in the comments. I love knowing where these stories travel. And please share this with someone who should probably dig out their original employment contract. I'll see you next time.